folks, Rob Wells with you, Law Office Robert Wells, Landlord Warrior on TikTok, answering another YouTube question. This question involved the disclosure required under the Tenants Protection Act for separate but alienable pieces of property, single-family homeowners, condos. Question was, long-term tenant lived at the property for 12 plus years down in Riverside County. Gonna be honest with you, I'm just gonna state the state law. I don't know if there's any other additional restrictions on evictions down in San Bernardino County. As always, check your local listings, make sure you're following your local ordinances, because there's several that are in place right now in the state. But the question basically was, the landlord was going out of business, tenant's been there long term. The landlord gave the no fault just cause type of termination of tenancy for withdrawing his property off the residential rental market. And the tenant's question was, did they have the landlord never gave the disclosure required under AB 1482, and was that permissible? And the answer is yes, because if your landlord is terminating the tenancy for no fault just cause for withdrawing the residential property off the rental market, they don't need to give you the exemption. They're actually terminating it for the no fault just cause for going out of business, basically. Now, two caveats though. In this situation, the question involved, can the successor landlord, I guess the former landlord sold the property to a new landlord, can the successor landlord use that notice? Yes, with an asterisk. And I say that with an asterisk because if the successor landlord is not intending to withdraw the property off the residential rental market as stated in the notice, then that landlord is not going to be able to use that notice to terminate the tenancy, because the whole idea is you're terminating the tenancy for a permissible reason under the Tenants Protection Act, and if you're not going to follow through with it, you're going to have a problem in court. This also brings another issue that I want to just bring up to landlords in general is think before you terminate your tenancy, particularly if you're going to sell the property, because your new buyer may need to issue their own notice. For example, owner move-in type of eviction. That's a permissible no fault just cause eviction to allow an owner or their qualified relative to move in. Well, guess what? Landlord that's selling the property, you're not going to be able to issue that notice if you're selling it to someone else, because the successor landlord would need to state they are moving into the property, he or she or the qualified relative. And again, for qualified relatives, it's basically spouse, domestic partner, child, grandchild, parents, grandparents. Under the Tenants Protection Act, first degree relatives. So brothers, sisters, anything in the second degree, that's not going to qualify because it's actually written in the TPA, for example. So before you terminate a tenancy, you probably want to speak to someone, particularly if you have different plans for use of the property, and your local eviction restrictions may apply in the county that you're in or the city that you're in. So better to check your listings than trying to retract a notice and then figuring it out later on that your notice might have issues. So hopefully that answers the question. Till the next time, folks, we'll talk to you then. Thanks.